You're watching the legal breakdown. So, Glenn, we've got a bombshell ruling that Trump doesn't have presidential immunity, meaning he can be sued in civil trials for inciting the insurrection on January 6th. So, first off, what will be the result of this ruling?
Well, the result is the civil suit that was brought by two Capitol Police officers and about a dozen members of Congress who were, in the Capitol that day, who were victims of the Trump, inspired or incited attack on the Capitol. Their lawsuit against Donald Trump will move forward because the court ruled he does not have presidential act immunity. So it will continue to move through the system. They'll go through discovery. And assuming Trump doesn't try to settle the case, and when has he ever settled the case and accepted responsibility for any of his wrongdoing, the case will move to a civil trial.
And so, does this open the floodgates now for other civil litigation?
It certainly opens the floodgates for anybody who was at the Capitol that day, because as part and parcel of suing somebody, you have to prove damages. Certainly, the people who were in the Capitol that day suffered damages. I mean, extreme emotional distress, if nothing else. The Capitol was under attack, was under siege. Police officers were being assaulted. And we've all seen the members of Congress down on the floor, scrambling for gas masks, trying to get to safety. Obviously, they suffered provable damages. So there might very well be more lawsuits brought by folks who were in the Capitol that day.
Now, what about those who weren't in the Capitol? Like who has standing to sue Trump? Does it have to be somebody who was provably and directly harmed by the events of January 6th?
Yeah, Brian, that's a great question. How far might civil liability extend? So I think a rule of thumb is you have to sort of suffer some direct consequences, some harm, some provable damage as a result of the other litigant's conduct, the person you're suing. Now, we all know Donald Trump tried to steal our votes, tried to overturn the results of a free and fair presidential election and install himself in power, contrary to the expressed will of the American voters. So, you might look at it and say, well, aren't we all victims? Aren't all Americans, at least all Americans who voted in the 2020 presidential election, technically victims? And I think technically or practically speaking, we are victims, but I don't know that we could prove damages in a court of law in a civil suit. The reason I say that is because he was not successful in basically negating our votes. He tried mightily, but ultimately Joe Biden was sworn in on January 20th, and he has been the president ever since. So I actually think it would be hard to expand the class of plaintiffs beyond the people who suffered, direct damage as a result of being present in the Capitol that day. But let me tell you, there are, no examples to turn to, historic examples or precedential examples to say, okay, who might be able to bring suit and who might not be able to bring suit. These are the kind of things that only courts can decide based on the evidence in the case.
Okay, well, would it be likely that we could see a raft of different January 6th lawsuits from all different January 6th plaintiffs, aside from the one for which this decision was handed down? Or would they move to consolidate any cases against Trump if it relates to January 6th into one case?
Yeah, these are great questions for a civil procedure class, and there are no easy answers, but let me try to tackle it. First of all, how could we not see more cases brought by the thousands of people who really did suffer and really were in harm's way because they were in the Capitol that day? This was something of a test case, right? It involves 12 or 14 plaintiffs, but now it looks like it is a viable legal claim. It's a viable theory of liability now that the court has said, no, Donald Trump does not have presidential act immunity. He can be sued. So why wouldn't more people who suffered harm on January 6th as a result of Donald Trump's conduct bring suit? Then the next question you ask is, would those suits necessarily be consolidated? I think they are likely to be consolidated into one suit. Obviously, all of the claims would be similar. I was in the Capitol that day, and I suffered damage as a result of Donald Trump's conduct. So I do think you may see more lawsuits filed, or you may see more plaintiffs filing motions to join the suit that has now been approved by the D.C. Circuit Court of Appeals.
Now, what about the insurrectionists themselves? 1,000 of whom were charged, who can kind of claim that who have claimed already in court that the reason they were there is because they were incited to be there by Donald Trump. Do they have standing now to come forward and say, our lives were turned upside down because we were summoned to the Capitol by the former president of the United States? Do they have standing to sue him?
This is more of a law school exam question, but I want to go right to the practical answer. There is something called the clean hands doctrine. What courts really do not like is when somebody comes in with unclean hands. In other words, I'm an insurrectionist. I followed Donald Trump's orders and I committed all kinds of crimes at the Capitol. Now I want to blame Donald Trump for inspiring my criminal conduct. The courts will often say under those circumstances, Brian, you have unclean hands. If you didn't commit any crimes and you merely suffered damage or harm because of what Donald Trump said or did, or what you did lawfully in reliance on what he said or did, maybe we would hear you to complain. Maybe you would have a viable lawsuit to bring. But, once you decided to engage in criminal conduct, even if it was inspired by the lies of another, you're probably not going to have a viable lawsuit to bring against Donald Trump under those circumstances.
Okay, got it. And not to bury the lead here, but what are the implications of this ruling on Donald Trump's Washington, D.C. criminal trial?
I love this piece of it because, this doesn't directly answer the question, can Donald Trump be prosecuted criminally, or does he have some kind of magical unicorn absolute immunity from being criminally prosecuted? This is really an important, what I'll call atmospheric precedent. Why do I call it atmospheric precedent? It's not legal precedent. It's not like the criminal courts will now say, oh, the civil case was resolved in the following way, therefore we will apply it as precedent to the criminal case. But it's atmospheric precedent. It lends support for the conclusion that if you can be sued civilly, where presidents have lots of protection because of presidential act immunity, but if you can't even clear that bar, well, if you committed crimes while president, there's no way you've got any lingering immunity left in any view of the state of the law. So it really is kind of important. And it's interesting because the appellate court said, look, what you were doing, Donald Trump, on and around January 6th, apart from the fact that you've been criminally indicted, you were committing crimes, is you were trying to regain power. You were trying to override the expressed will of the American voters. And there's one thing that is not. It's not a presidential act. It's the act of a candidate. And that is really one of the pegs on which the three-judge panel hung their hat, their legal decision. They said this can't possibly be a presidential act because it was the act of a candidate if it was any kind of a lawful act. But we're going to learn more about, I think, the view of the law moving forward, because not only was it not a presidential act, it was an illegal act. And that's why at the end of the day, he's not going to enjoy any immunity civilly or criminally.
Glenn, can this decision be appealed to the Supreme Court, or is this binding?
Can and will be. I can almost guarantee two things will happen. When a three-judge appellate court panel issues an opinion,
or sorry to interrupt, but will they seek an en banc review from the entire court and then go to the Supreme Court?
See, you're becoming a lay lawyer now because you answered the question that I was going to answer, and you're exactly right. The first thing they'll do is they'll take this decision by the three-judge panel and they will seek review en banc, fancy term for full court. They will ask the entire appellate court, which consists of 8, 10, 12 judges. I haven't counted them up recently, to hear the court and resolve it with all of the appellate court judges sitting in judgment. And one way or another, regardless of whether it goes en banc or not, it will undoubtedly be appealed up to the Supreme Court. The question becomes, will the Supreme Court accept review, or will they just say, you know what? There is no constitutional principle at play here. He was not acting as the president. He was acting as a candidate. So by all of the precedent, and there is some precedent, the Nixon case, the Clinton case, which are cited in this court opinion, by all of the available precedent, he does not have immunity from being sued civilly. And that's the only question that needed to be answered in this case. So if I had to bet my buck, Brian, not a betting man, not a high roller, I would probably put a buck on the Supreme Court not accepting review of this case.
Okay, well, we'll obviously stay on top of this as soon as we have any developments, not only in terms of what the courts do, but also in terms of how these lawsuits progress, and if we see any other plaintiffs kind of add themselves to the ongoing litigation against Donald Trump. So with that said, if you want to follow along, make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.